to talk about substance abuse in the ADA. We have Tate Gray, an attorney from LRB Thompson, who's going to present here. Just before we get started, again, want to encourage you all to participate by asking questions. You can either raise your hand or type a question. So the more interactive, the better. I think Tate is going to try and do some scenarios and might want to have people participate. So if you want to participate, raise your hands. If not, I might volunteer you. Again, I will, when we're concluded with this particular webinar, I will send out the presentation and a recording of the presentation and any other documents that Tate would like to include. So without further ado, if you could all stand and applaud, here is Tate Gray.
Well, thank you very much for that introduction, Dan. I appreciate it. And as he said, my name is Tate Gray, and I'm here from LRB Thompson. I'm here to talk about the ADA and substance abuse. Just to quickly go over, oh, actually, I don't think my clicker is working. Oh, there we go. To quickly go over the agenda, first I'm going to do a very quick overview of the Americans with Disabilities Act, kind of as a refresher course, just to kind of set the mood and kind of reintroduce everyone. I'm sure everyone's heard about the ADA and reasonable accommodations ad nauseum, but I think it's a good thing to kind of set the tone for the rest of the presentation. Then we're going to segue into talking about illegal drugs and how that intersects with the ADA. And then we're going to do the same with alcohol and how that intersects with the ADA. So the Americans with Disabilities Act was passed by Congress in 1990 to make it easier for people with disabilities to go about their daily lives. The law has three parts: Title I, which is applicable to all employers, well, the vast majority of employers. Title II, which is applicable to state and local governmental entities. And Title III, which is applicable to places open to the public, such as movie theaters, stadiums, things like that, places that invite the public onto their premises for some kind of services, event, or anything like that. So a little bit more about Title I. Title I of the ADA is a federal law granting employees with disabilities, which are defined as an impairment that substantially limits the ability to do important tasks, the right to request accommodation that helps them go about do the essential functions of their job. This is probably where each of us has most often interacted with the ADA. Now, Title II prohibits excluding qualified individuals with disabilities from participation in the benefits of services, programs, or activities provided by a public entity. This can also encompass public employment. This is maybe think about your public libraries, places where the public is invited by the public entity itself to come onto the premises. Title III prohibits discrimination on the basis of disability in the activities of places of public accommodations. Again, another example of this would be like restaurants, things of that nature. But this is not applicable to local governments. Again, this is just a kind of a refresher course just to set the tone. ADA Titles I and II of the ADA require employers to provide reasonable accommodations to qualified individuals with disabilities who are employees or applicants for employment, unless doing so would cause an undue hardship or directly threaten the health or safety of the employee or others. An accommodation, an employment accommodation, is essentially any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. Providing a reasonable accommodation is a fundamental requirement under the ADA. Reasonable accommodations must be provided to qualified employees, regardless of whether they work part-time or full-time or probationary. Generally, the employer with a disability, the individual with a disability, must inform the employer that an accommodation is needed. Now, these are some examples of possible types of accommodations that we've probably all dealt with. It can be things like making existing facilities accessible, such as putting in a ramp for someone who's wheelchair bound. It could be job restructuring, part-time or modified work schedules, acquiring or modifying equipment, changing policies, providing readers or interpreters, reassignment, leave, or any nature or any number of changes to the work environment. Now, what is reasonable? An accommodation is generally reasonable if it is feasible and is effective in meeting the needs of the individual. In the context of job performance, a reasonable accommodation enables the employee to perform the essential functions of his or her position. It allows the applicant to fully participate and be considered for the job. Which begs the question, what is an undue hardship? Undue hardship generally means significant difficulty or expense and focuses on the resources and circumstances of the employer in relation to the cost or difficulty of providing a specific accommodation. It refers to both financial difficulty and accommodations that are unduly disruptive or would fundamentally alter the nature or operations of a business. And this will vary from employer to employer. What's reasonable or what's an undue hardship for a small municipality with only a few employees will not necessarily be undue hardship for, say, the city of Atlanta, who has access to a lot of resources. Request for accommodation. Accommodations must be requested, but need not mention the ADA specifically. There are no magic words. Plain English is acceptable. Also, family, friends, health professionals, they may also make the request on behalf of the employee. They need not be in writing. And once received, the employer must engage in an interactive process with the employee to identify possible reasonable accommodations. Now, a quick overview of the interactive process. The employer may obtain clarifying information about the nature of the disability and appropriate form of accommodation. You can and should require employees to use a form to gather basic information to start the process. You may ask for documentation if related to the existence of a disability and necessity of an accommodation if the disability is not obvious. You can agree to a trial period and then reassess after that trial period. You're required to provide a reasonable accommodation, but not necessarily the accommodation desired or requested by the employee. Now, getting to the meat of what our webinar today is about, it's talking about how the ADA and substance abuse intersects, and it's divided up between illegal drugs and alcohol because the ADA actually treats those two substances very, very differently, as we'll hear about to see here. So, with respect to illegal drugs, the illegal use of drugs is expressly excluded as a disability under the ADA. The illegal use of drugs is defined as the use of drugs, the possession or distribution of which is unlawful under the Controlled Substances Act. Furthermore, the illegal use of drugs excludes the illegal misuse of pain-killing drugs, which are controlled by prescription. So it's important to realize that the illegal use of drugs is dependent on federal law and not necessarily state law. It's less important in Georgia, but if you were in a state where, let's say marijuana was legal recreationally, the ADA would still or would not necessarily expand based on that legality of the drug because it's still technically illegal under the Controlled Substances Act. Now, a little bit more about the Controlled Substances Act. I'm going to readily admit I am not an expert in the field of federal law as it relates to the Controlled Substances Act, but here's a brief overview. The Act divides drugs into multiple schedules that are primarily based on the drug's potential for abuse and the accepted medical use. Schedule 1 drugs, such as heroin, LSD, MDMA, and marijuana, may not be legally prescribed at the federal level. They're essentially illegal, no matter what, at the federal level, that is. Schedule 2 and Schedule 3 drugs, which include most prescription drugs, are generally legal if prescribed by the appropriate medical professional. Now, going back to whether it's the legal use of drugs, let's say you have a prescription drug that is being taken illegally, that would still be a legal use of the drug and would not be protected by the ADA. An individually currently engaged in the illegal use of drugs is not a qualified individual within the meaning of the ADA. Currently means that the drug use was sufficiently recent to justify the employer's reasonable belief that the drug abuse remains an ongoing problem. So in other words, it depends. It depends on the situation. It depends on the time that's elapsed since the individual has stopped using the drugs. It depends on how addicted that person may or may not have been. There's many factors that can go into that. We're going to go through a couple scenarios that kind of illustrate that. So, according to one federal appellate court, a current user is one who has used illegal drugs in the weeks and months preceding an adverse employment action. According to the court, 30 days was insufficient as a matter of law for the plaintiff to establish he was no longer currently using drugs. So according to the 10th Circuit, at least, if an individual has used, excuse me, I jumped ahead there. There we go. According to the 10th Circuit, at least, if an individual has used drugs in the past 30 days, he is still a current user of drugs and not protected by the ADA whatsoever. That's as a matter of law, no matter the circumstances. Another federal court similarly held that 5 weeks is such a short period of abstinence, particularly following a severe drug problem, that it does not remove from the employer's mind a reasonable belief that the drug use remains a problem. Now here, this actually begs the question, what happens if it's not a severe drug problem? What if someone used drugs one time 5 weeks ago? I'd be interested to see what that court is, and that actually has not been specifically addressed, at least not in the 5th Circuit or the 11th Circuit. But I point that out just to illustrate that there's multiple factors that go into determining whether someone is currently using drugs and therefore not protected by the ADA. Another court summarizes the widely accepted view on the current use of drugs by holding that the ADA's legislative history indicates that Congress had in mind a drug-free period of some considerable length, a long-term abstinence from drug use, not an immediate one. However, the ADA also has what's called, it's been commonly called the safe harbor. Despite the ADA's general exclusion of an individual's illegal drug use from the definition of a disability, an individual who no longer engages in the illegal use of drugs, i.e. they're not a current user, and has successfully completed a supervised drug rehabilitation program or has otherwise been rehabilitated successfully, is participating in such a program, or is erroneously regarded as engaging in illegal drug use, may still be protected as an individual with a disability. So take this hypothetical to kind of flush out what we've been talking about. Amy is a nurse who became addicted to prescription pain medications that she was illegally obtaining at the hospital where she worked. While the hospital investigated the matter, the nurse entered a drug rehabilitation program. Upon successfully completing the program, Amy was immediately fired by her employer. Now, does anybody think, is there any problem with the employer's actions? And this is the time that you could feel free to chime in. I understand that we're kind of limited by the format, but if anybody has some thoughts, feel free to jump in. If not, I can just work through it kind of orally.
Let's touch base and see. Sarah, are you out there? What's your thoughts?
I have no thoughts right now.
Sorry for putting you on the spot. Let's see. Oh, Sherry Sale ahead. Let me see. Sherry, are you out there? You got a thought on this? Your microphone's not working. If you got it, type your response. Was it good or bad? Or how about this? Raise your hand if you think they were legal. Raise your hand if you think that there's not any legal issues with what they did. Got here, I would say should have let her return to work, review her outcome to treatment with random screening. What's your thoughts on that?
I actually don't think that's a bad response. I certainly think that would be legal. I mean, there would be absolutely nothing wrong with that because, one, you're not really taking any kind of adverse employment action against her, especially if that kind of, if that's one, provided for in policy, or two, it's how you react anytime someone has a drug issue that they'd have to go to some kind of rehabilitation program. If that's the consistent way that an employer handles that kind of issue, I think that would be an appropriate response, absolutely.
We got another kind of question comment. She stole the pills, fire her for stealing.
Yes, and actually that is how one federal court, exactly how a federal court approached this issue here. And I'll go to that and kind of talk a little bit more about that now.
We got one more comment.
one more? Okay.
And again, Victor, you out there? You had your hand raised? Victor? You got a comment, Victor, or question? Okay, we'll continue on.
All right. Now, as the last person said, this is almost exactly what happened in a Fourth Circuit case. The appellate court upheld the district court's grant of summary judgment and the dismissal of Amy's ADA claims here. In doing so, the court noted that excluding Amy from the protections of the ADA was in line with Congress's intent of ensuring that employers would be able to discharge or deny employment to persons who illegally use drugs on that basis without fear of being held liable for discrimination. Now, as someone had mentioned, the stealing was a component of that as well, which is in and of itself something that would have been obviously a violation of the policy. And that's something that we'll talk more about later on, is that even though someone may be having some kind of substance abuse issue, especially this is more relevant when it becomes when we get to alcohol, which has further protections, an employer has no obligation to adjust their disciplinary policies or standards or reactions based on that person's substance abuse. If they violate policy, then they're violating policy. You can take action based on that basis. So here's a similar hypothetical, but a slight tweak to it. In this hypothetical, Ted is a nurse who seeks an accommodation in the form of periodic leave to attend Narcotics Anonymous, which is recommended by his doctor. Here, Narcotics Anonymous, if you're not aware, is essentially the same as Alcoholics Anonymous. It's a support group for people that have formerly or are currently addicted to narcotics. But he explains that before nursing school, several years ago, he was addicted to painkillers, but recovered after undergoing a treatment program. Upon learning about Ted's past drug use, his employer immediately terminates him. Now, does anybody think there's a problem here?
We have somebody, again, no problem. The distance between which he was a user, and hold on a second. User, he should be fine. Let him go to NA. What's your thoughts on that?
Well, I think that would probably be the best approach here. I don't want to say that he is automatically protected under the ADA, because he still has to prove that he has a disability within the meaning of the ADA. Here, a doctor would likely conclude that he did have a disability, or at least be able to put forth in the supporting documentation that a court would decide that. But Ted in this situation has a lot more protections under the ADA than Amy in our last one. And it's exactly as the person who commented on it. It's because he is no longer that current user of drugs here. It's been several years. He's gone to a rehabilitation program, so he falls within that safe harbor. Now, if he could prove, if his employer did in fact terminate him under these circumstances, he was able to prove that he had a disability, then the employer would be liable for a violation of the ADA.
And again, a comment or question, which, when, I'm not sure exactly what that means. Sherry, if you can explain that, that would be great. Continue on, I'm sure we'll get another response. Oh, here it is. I typed that wrong. I said which, when, it should have been, okay, when. Okay, very good. So I think she was just explaining her question.
Okay.
Thank you.
And this is a slide just kind of explaining what I was just talking about. Here, the employer potentially violated the ADA if Ted were able to prove that he had a disability within the meaning of the ADA. He would potentially have fallen in that safe harbor as he was not a current user and successfully completed a rehab program. Now we're going to segue into a discussion of alcohol. With legal drugs, it's pretty cut and dry. If you're a current user, you're just not qualified, or you're not a qualified individual, you're not entitled to the protections of the ADA. However, as you'll see, which is probably not surprising, is that alcohol is treated much differently, primarily, I assume, because it's a legal substance. It has been at the time that the ADA was passed. It's also, socially more acceptable in most circles, I think, which was factors into Congress's intent in providing protection for alcohol use. But under the ADA, alcoholism is generally considered a protected disability. There are some I don't want to say disagreements, but I will say varying levels of support for that among the different circuit courts. Some circuits say unequivocally in all situations, if someone's an alcoholic, they have a protected disability. Other circuits approach it more on a case-by-case basis, but almost always, if you're a full-blown, alcoholic in the sense that it's affecting your work and that you are requesting an accommodation, that you very likely have a disability because it's substantially affecting one or more major life activities. But an alcoholic is likely protected by the ADA, even if the alcoholic is currently using alcohol on a regular basis, unless that use renders the individual unqualified. And when I say unqualified, it just means that one example, it could interfere with a job performance. It could lead to other conduct issues that make him unqualified for the position. Therefore, an alcoholic person with a disability under the ADA may be entitled to a reasonable accommodation if qualified to perform the essential functions of the job. And this is kind of going back to what I was speaking about earlier. Even though courts generally determine that alcoholism is a covered disability, the ADA makes it clear that employers can enforce rules concerning alcohol in the workplace. And this includes general performance-based policies and conduct-related policies. The ADA provides that employers may prohibit the use of alcohol in the workplace, which I'm sure everyone has that type of policy in place. They can require that employees not be under the influence of alcohol in the workplace, which again, it's a pretty commonly held policy. And 3, which is the major one, hold an employee with alcoholism to the same employment standards to which the employer holds other employees, even if the unsatisfactory performance or behavior is related to the alcoholism. And we'll talk about this more, but you can essentially the employee cannot essentially use alcoholism as a crutch or an excuse for otherwise poor conduct or performance. So consider this hypothetical. Chris is an alcoholic who is often late to work, is unable to keep up with his workload, and often presents himself at work unprofessionally. And when I say that, he shows up, he doesn't look, he's not quite up to dress standards, he looks a little disheveled, things of that nature. Chris's employer takes disciplinary action based on these deficiencies. Does anybody think there's a problem with this?
Thoughts from anyone? No problem. Discipline him.
Let's say that the employer even knows that he's an alcoholic, adding that little tweak to it.
No problem, another person says.
That's basically right. I guess the previous slide kind of gives that one away. But generally, there would be no problem with an employer taking disciplinary action, so long as the action is equal to that which the employer would impose against a person who is not an alcoholic. So you can't discipline, what was his name again? Let's see, Chris. You can't discipline Chris more on the basis that he's an alcoholic than you would someone who engaged in the same activity, but is an employer may not. Yeah, that's what I just said. So here's another hypothetical that kind of illustrates that. And we don't necessarily have to go through the question and answer as it should be obvious, but Tom is an alcoholic, Tom, who is an alcoholic, and Sarah, who is not, are caught by their manager having a beer in the warehouse in which they work. Drinking alcohol on premises is a violation of the employer's policy. The employer terminates Chris due to the concern that his risk as a status as an alcoholic creates additional risk while only suspending Sarah. And this kind of just illustrates the opposite side of that. There would be a problem with that. That would be discriminating against someone on the basis of their disability. Here, you're treating Tom differently because he's an alcoholic than you are Sarah, who's not, which is essentially the classic case of discrimination. Now, this hypothetical also assumes that these people also have a similar disciplinary history and everything like that. All things being equal, you can't do that. If Tom, if Tom had previous incidents with alcohol or previous conduct issues where Sarah didn't, then that may justify different treatment. But if everything's equal, you can't treat those people differently on the basis of one being an alcoholic and one not, just like any other disability. So what happens if an employee mentions drug addiction or alcoholism and requests an accommodation for the first time in response to discipline for poor performance or conduct? Does anybody have any thoughts on that?
Any comments, any thoughts? What happens?
And in this scenario, let's say someone's getting in trouble before they
Just, I think we have a legal comment here.
Okay.
Too bad, too sad. Should have spoke up before.
Well, in a sense, that is right. It's not necessarily always that cut and dry. But yes, someone cannot raise this issue for the first time and then expect that to exonerate any poor performance or conduct that they may have already committed that is already in the works, the disciplinary action that's already in the works. Okay.
Go ahead.
All right. So in such a situation, the employer may still impose the same discipline that it would have for any other employee who fails to meet its performance standards or who violates uniformly applied employment policies. If the appropriate action is termination, the ADA does not require further discussion about the employer's alleged disability or request for accommodation. However, if you're not terminating this person, if you're just doing some other form of disciplinary, and they do, in fact, do you have a question?
Yeah, somebody had written, could offer EPA as part of a disciplinary action? I'm not sure if that's a statement or a question.
Yeah, if it is a question, then I think that would be an appropriate action. So you don't have to hold off on the disciplinary action, but now you know. Now the employer is on notice that this person, let's use alcoholism, because that is a protected disability under the ADA. Now the employer is on notice about this disability, and you have to treat it just like you would any other time you're put on notice of a disability. So you don't have to forestall the discipline, but it does kick in the protections of the ADA. They can be bifurcated, essentially. So, as I was saying, an employee whose poor performance or conduct is attributable to alcoholism may be entitled to a reasonable accommodation, which is separate from any disciplinary action the employer chooses to impose, and assuming that the discipline in question is not termination. If an employee only mentions alcoholism but makes no accommodation request, the employer may ask if an accommodation would prevent further issues. And again, this is just the normal ADA, interactive process at this point. If an employee does request an accommodation, the employer should begin the interactive process to determine if an accommodation is needed to correct the problem. The discussion may include questions about the connection between the alcoholism and performance or conduct deficiencies. The employer should seek input from the employee and may offer suggestions. And examples of accommodations include modified work schedule to allow the employee to seek treatment. However, as I said before, there's any number of accommodations that could be appropriate under the circumstances. So here's another hypothetical. Consider Chris, who we talked about from the earlier hypothetical. He was regularly late for work, he struggled to keep up with his workload, and presented unprofessionally. Chris's employer, who is unaware of Chris's alcoholism, seeks to issue an unpaid suspension. When Chris is told of the suspension, he admits to being an alcoholic and requests an accommodation. What should the employer do? And again, this one should probably be pretty self-explanatory given the past slides that we've had so far.
Thoughts, anyone? I would discipline him as would anyone else, but when he comes back, have the interactive discussion.
That's exactly right. That is the appropriate response. And I would maintain that not only can you impose that discipline, I think that you should impose that discipline. Because by not, if let's say, for example, an employer did not want to impose that discipline after they find out, let's say they have the letter in their hand, that's going to notify them that Chris is going to go on an indefinite suspension. He says that, then it causes the decision maker to rethink that decision. Now you're essentially creating a situation where you're treating employees different based on a disability. Here, it's not an adverse action, but what happens when you deal with the next employee? Let's say that the next employee does the same thing, and you then impose discipline to that subsequent employer. Now we're kind of in this catch-22 where we're not uniformly imposing our own employment policies. So I maintain that you could and should impose that suspension still. However, the employer now has the obligation, and it is an obligation that's imposed by the ADA to begin the interactive process to determine if there are any reasonable accommodations that would prevent further problems.
Here we have, you always have to beat everyone with the same stick.
That's exactly,
LOL.
that's exactly right. That's what we're going for. I do like the analogy too. So, still segueing off that same hypothetical, let's assume that Chris is offered a modified schedule that allows him to attend Alcoholics Anonymous, AA meetings during the workday. Chris's coworkers start to ask questions about his regular absences. How should the employer respond? Any thoughts on that?
Any thoughts? Come on, I know you guys have thoughts out there. Let's see. How do you determine that someone is an alcoholic? Drinking every night? Just on weekends? Any thoughts on that question?
I do. My first thought would be that I am not a medical professional, so I am not qualified to make that determination. But it's just like with any disability. You have the ability to request medical documentation from a medical provider who would be more appropriate to make that decision. I think, I mean, there's lots of non-obvious disabilities out there, and the way that we confirm that is by requesting that medical information from the individual's provider. And I think it's the same with alcoholism here. It's not a decision that I think that someone in HR or the attorney should make. It should be in conjunction with the employee with input from the medical provider.
So the comment regarding the scenario you provided, it states, I would state that he has permission, again, Chris has permission to be gone, so stay in your own lane. Mind your own beeswax.
I think that's a very appropriate response there. Again, we're dealing with just another disability, and that could probably be the theme for at least the alcoholism portion of this, is that this is no different than any other disability that an employer may deal with. Under the ADA's confidentiality provisions, Chris's employer may not tell coworkers that Chris has a disability or is receiving a reasonable accommodation. Therefore, it's imperative that we train managers and that managers are trained about how to respond to such questions. Chris's manager could simply respond that she does not discuss one employee's situation with others in order to protect the privacy of all. But she could assure coworkers that Chris is meeting expectations, or as the commenter was saying, that he has permission to be absent from work during the specific time. But beyond that, I think that's probably the extent of what you can say, is that there is permission.
Do you know how to mind beeswax? No?
No, I don't. I like honey. So something that comes up in the context of the ADA commonly is last chance agreements. I don't know if anyone here has dealt with them, and it may be something that actually comes up more in the private sector. But last chance agreements, the first thing to know about them, they're not required by the ADA. An employer may choose, but is not required by the ADA to offer a last chance agreement. However, a lot of employers do find it useful, especially when someone is dealing with some performance issues that are maybe borderline. Maybe there hasn't been a very overtly egregious incident that's led to this, but someone's addiction or alcoholism is a concern in the workplace. So under a last chance agreement, an employer agrees not to terminate an employee in exchange for the employee's agreement to receive substance abuse treatment, refrain from further use of alcohol or drugs, and or avoid further workplace problems. Violations of these agreements typically result in immediate termination. It's one way that employers deal with the situation. Yes.
Got a comment. We have used them in private sector. They had to complete an EPA mandated program and regular drug testing.
Yes, and I think that it's basically the nuts and bolts of it. It kind of gives the employer, it's a benefit for the employer and the employee. For the employer, it offers a chance to avoid potential liability from taking a final action at least maybe a final action that may, like I said, be in a borderline situation, but it also offers the employee the chance to rehabilitate themselves, which, is arguably, or not, I won't say arguably, which, is a good thing, assuming that they can successfully do that. But the important thing to realize about this, while it could be useful, it is not required under the ADA by any means. I think, at least maybe in the past, there has been some confusion about that, and that's why I included this slide. Predominantly is just to kind of give you an option to tell you that's out there, and I think it is used primarily in private practice as opposed to the public sector, but it's not required by the ADA. So that's my last slide. Are there any questions? Any general questions? Or specific questions, either one?
Questions, comments, anybody want to talk? Raise your hand or write a question. We'll see what we can do about getting interactive here. You guys have done great as an audience, lots of interaction, really appreciate it, and appreciate Tate's work on this. I think the scenario things really work out well, so thank you for that. Any other thoughts? Well, with that said, here's this question, what about the CBD oil utilization? Any news on that?
That's an interesting issue. We've been getting a lot of questions about that. For the past couple of years, I would say, at the firm. I think our take on it has been is that, I think most employers have drug testing policies. I think that those policies should be enforced. CBD, based on my research, at least in Georgia, in order to be legal, has to be below a certain percentage of THC in order for it to be legal, essentially. Typically, that amount of THC, and THC is the compound in marijuana and cannabis that makes a person fail a drug test, essentially. It's a psychoactive element of it. So CBD doesn't have that element in it, or it has a minuscule amount in it that really, is basically negligible. So based on my research, someone who's taking CBD is probably not going to fail a drug test. Therefore, they're not really violating any employment policies unless there's an employment policy that says, you can't do CBD, in which case it would be a direct violation. But I think our firm stance on it has been, use at your own risk, but if you fail a drug test, we're not carving out an exception. It's not an excuse, so to speak, that you've just been using CBD. And I think there is some risk involved with taking CBD, is because a lot of it, at least based on my research again, is mislabeled. It can be mislabeled. You're dealing with not all the time very sophisticated companies, or at least varying levels of sophistication. So they don't always know how much THC is actually in that thing. So I think our general stance has been that an employee, assuming that there's no direct policy saying otherwise, if they use at their own risk and fail, then that's kind of on them. But the employer should definitely enforce their own policies equally and not carve out any kind of exception for that. I haven't heard about it from a reasonable accommodation standpoint, because typically, you don't really have doctors. At least in my experience, I haven't seen a doctor on an ADA paperwork prescribe CBD as an accommodation or anything like that. If that were to come up, I think that would require maybe some different, a different analysis. But again, it comes back to, if you have a drug, a policy that says that if you fail for THC, then you get disciplined, and they do. I don't think the ADA is going to protect that use of CBD, because the THC, according to the controlled substance, or THC, excuse me, is still an illegal compound. So that would be technically, if in high enough concentrations, would be the illegal use of drugs. So again, there's a lot of factors that go into that. It's a complicated issue. But I think if you just kind of stick to your guns on the policy, and if they violate the policy, then it is what it is at that point.
So I got a comment here. Great job. I learned a lot. And then kind of more of a comment suggestion. Looking forward to more information on implementing a drug policy. Test everyone initially. We are a small municipality and have some long-term employees that are marginal, if you know what I mean. So, again, I think Pam will probably do an additional webinar on the implementation, on how to implement a substance abuse policy. But do you have any thoughts in regards to that?
Yeah, that's another kind of sticky situation when we're talking about pre-employment drug testing, especially when we're talking about across the board pre-employment drug testing, because we are all public entities here. The Fourth Amendment does apply to public entities. The Fourth Amendment being, you can't conduct unreasonable search and seizures. There have been courts that have ruled that, a drug test under certain situations could be a search and seizure. It has Fourth Amendment implications. So certainly you can drug test with safety sensitive positions. I'm not saying that you shouldn't do across the board, drug testing necessarily, but there are those implications. I think that is a very big area of the law that require a lot of diving into. But there are implications there. So that's kind of my initial thoughts right there.
Okay. Very good. Very good. Well, thank you so much, Tate. I really appreciate it. Everybody stand up. And again, if you got another comment, that would be a great class. So we'll put that on the agenda. Thank you guys all for participating. We really appreciate it. Have a wonderful rest of the evening, and go Dogs. Talk to you later.
Thank you.